Good evening, and thank you for joining us as the University of the West Indies Faculty of Sport and Faculty of Law present this special forum under the theme Sports Law, Governance, Regulations, and COVID-19. Now, the global pandemic has had a significant impact on the sporting world, from bringing activity virtually to a halt to giving new life to innovation. However, it has also thrown up some potentially interesting challenges in the areas of law and governance, some of which we will discuss today. I am Marsha Boyce, your moderator for this evening. And by we, I mean this excellent panel that we've assembled to guide us on this legal journey. I have with me first up Dr. Jason Haynes. Dr. Haynes is a lecturer in sports law at the UWI Cave campus, as well as Deputy Dean of Graduate Studies and Research. He's a co-author of Commonwealth Caribbean Sports Law and has published regularly in leading international sports law journals. As a consultant, Dr. Haynes has also worked with the Caribbean Association of National Olympic Committees, KNOC, and is a world intellectual property consultant on sports, entertainment, and IP law. With him is Dr. Justin Koo. Dr. Koo joined the Faculty of Law at the University of the West Indies St. Augustine campus in January 2017. And prior to joining UWI, Dr. Koo was a visiting lecturer at King's College London and a teaching fellow at the University College London. Now, his primary research interest is focused on copyright law, publishing several articles in this area. He's currently Deputy Dean of the Faculty of Law at St. Augustine campus, and he's also a football referee in Trinidad and Tobago. And last, but by no means least, Mr. J. Tyrone Marcus. He's an attorney at law admitted to practice in Trinidad and Tobago, Jamaica, and Barbados. He's an adjunct lecturer in sports law at the University of the West Indies and a past member of the NORCECA Volleyball Legal Commission. He's a former board member of the Caribbean Regional Anti-Doping Agency organization, that is, a past legal advisor of the Trinidad and Tobago Ministry of Sports, and has been specializing in sports law since 2006. Now, among his publications of articles and books, Mr. Marcus is also the author of Sports Law in Trinidad and Tobago, and along with Dr. Haynes is the co-author of Commonwealth Caribbean Sports Law. Now, all three of these gentlemen are currently the sports law lecturers at the University of the West Indies, with Dr. Haynes at Cave, Dr. Koo at St. Augustine, and Mr. Marcus at the Mona campus. So I'm in some very good company. Good evening, gentlemen.
Good evening, Marsha.
Good evening,
And
Marsha.
good evening,
Good
colleagues.
Evening, colleagues. Evening, everyone in the audience.
So, Dr. Haynes, I'm going to get the ball rolling with you. There's so many topical issues in sports law, sports governance right now. But international football was recently rocked with the announcement of a new European Super League, which initially involved 12 top clubs. But since then, we've had about 9 reported withdrawals. Now, there's a lot to unpack here, from governance to the threat of sanctions by UEFA and so forth. But interestingly, the Real Madrid football president, Florentino Perez, has openly said, you know what? These clubs have agreed they cannot leave because they've signed binding contracts. So, Dr. Haynes, take us through what are some of the major implications for such an arrangement as the ESL and the potential legal fallout.
Thanks very much, Marsha, for an excellent question, and a question which is contemporary and, of course, which is interesting. It is a question, of course, which I'm sure my fellow colleagues will pronounce on in a bit from now. But just to give some context to members of our audience who may not be aware, so the European Super League is in principle, or at least when it was viable, an initiative of several of Europe's leading clubs. It was intended indeed to compete with the UEFA tournament. Of course, UEFA is well recognized within the European context. It comprised many of the leading clubs from England and Wales, but also from Spain and many other European jurisdictions. And the intention was to allow for these clubs to participate in footballing activity at the European level in a manner which did not allow any of these clubs to be relegated but rather clubs that were outside of this small category would have to compete to potentially participate thereafter in footballing activity. So then, it, as you mentioned, gave rise to a number of complaints, a number of contestations, a number of views as well, ranging from clubs, but also the international community, as well as, of course, politicians became involved in argumentation around the legality of this particular proposed league. Now, the important thing to note in this context, first of all, is that breakaway leagues are not at all an isolated case in this particular context. We've seen them in many disciplines before. We've seen them in cricket, we've seen them in basketball, and several other sporting disciplines. This one is particularly troublesome because of the stakes that are in issue. The stakes are largely financial in nature. And in fact, the narrative which has been presented to date seems to suggest very strongly that this new initiative is intended to usurp the authority of UEFA, but also to advance the interest, the financial interest of a select group of clubs within Europe. And so that is how the narrative has been painted to date. The question then invariably arises, what are the legal implications arising from this new tournament that has been proposed? And of course, the fact that there's resistance from many quarters or in many quarters. Well, I think, first of all, perhaps the most significant of issues which arises in this context is one of a competition law issue. Now, competition law is referred in some jurisdictions as antitrust law. And the aim of this particular area of law is to prevent dominant undertakings or indeed anti-competitive business activity from transpiring, which would prevent the free flow of competition in a particular jurisdiction or combination of jurisdictions. It is provided for in the European Union treaties. And as much as sport is a private discipline as such, in that it involves private entities, the European courts have, over the years, become actively involved in this area of competition law, recognizing that there are serious implications for nationals and for governance and the rule of law, more generally speaking, if companies, if entities such as the European Super League were to engage in anti-competitive business conduct. So the first issue then is that of the prospect of this being regarded as anti-competitive business conduct. Now, in principle, there is no challenge as such in entities forming themselves together to achieve a particular outcome. In this particular instance, allowing for the footballing interest to grow and to generate revenue from among key stakeholders. The challenge, however, is that the way in which the European Super League has been proposed is that it raises competition law issues, in particular anti-competitive business conduct. Because what you have here is a select group of 12 of the leading teams, which can't be relegated. The challenge with that is that this is a concerted practice which is intended to drive out competition. And it goes against the fundamental tenets of European integration and its movement, which is to break down barriers, including anti-competitive barriers. However, the threats of sanction do in fact raise significant issues as well regarding the right to work of these individuals who participated, or at least elicited an intention to participate in this activity. There's this doctrine called restraint of trade, which exists in a contractual context, which provides that individuals should be allowed to conduct their work in the way in which they envisage, and there should not be unreasonable restrictions on their right to conduct work. And what we essentially have here is a situation in which effectively UEFA and others who are threatening the imposition of sanctions are curtailing these individuals' right to work. Now, we have had instances in case law in the past in which similar outcomes have been generated through, for example, the World Cricket Series of 1977-1979, led by Kerry Packer. In that particular instance, the court ultimately ruled that this movement on the part of the ICC to ban players who had participated in this so-called rogue exercise was in fact inconsistent with this notion of restraint of trade. And so it raises then a very interesting question for our consideration. What is the effect then of the potential of bans being imposed by these leading organizations as well as governments on these players and clubs that have chosen to participate in this particular exercise? The reality is they may very well be in breach of the rules regarding unlawful restraint of trade. But you also mentioned, Marsha, a really interesting consideration, which is that these individuals, many of them, have committed to this particular enterprise. They've indicated that contractually they wish to be bound by the terms and conditions associated with this enterprise. What happens then in the event that they pull out, as many of them have? Well, it raises a question as to whether or not the contracts in this particular instance would have been frustrated. Because if contracts can't be performed by virtue of the impossibility of the situation that had been created as a result of clubs leaving, then it means, therefore, that there is no practical utility of those contracts continuing in operation. It means then that there is, in principle, therefore, no sound argument as to be made that there is a breach of contract by these players and clubs in deciding to leave this particular enterprise, principally because if no teams are participating, there is no basis upon which the continued contractual relationship will, in fact, inure to the benefit of clubs on the one hand and indeed players. And as a result, we have this cacophony of issues, this debacle, as you might very well describe it, in which really and truly competition law is involved, contractual law is involved, but also arbitration is involved. The prospect that in the context of UEFA's statutes, but also FIFA statutes, provision is made for the resolution of these disputes almost exclusively at the level of the Court of Arbitration for Sport. Now, can a European Court of Justice intervene in this context when indeed jurisdiction should properly rest with the Court of Arbitration for Sport? The reality is the court has in previous years intervened, such as in the International Skating Union case, in which it was held that the imposition of penalties on players who decided to participate in activity not endorsed by the International Skating Union was in fact unlawful and in breach of EU competition law. Now, there's so much more to say, but I'll leave it to my colleagues who will join in due course in this conversation.
Well, definitely, Dr. Haynes, you've really set the stage for us with the ESL and with a pretty comprehensive overview of the various legal issues or legal considerations that we have. So, Dr. Kuhl, then, I'm going to stay with European football, but put you on the spot both as a legal mind and a football referee. Now, we're at the back end of the season across Europe, Champions League in full swing, the Premier League, etc. And it seems that almost every other week, VAR, the video assistant referee system, has been the subject of discussion. Now, there's a lot of debate whether the technology is flawed or whether the humans applying the technology are the ones where the flaws lie. So my question to you is, could we see a situation where VAR could become the center of a legal challenge? Say, for example, a club is denied a title because of it, or a club is faced with relegation because of a mistake made during a game?
Thanks for that, Marsha. And again, it's a really excellent question. But before I answer the question, I just want to tack on one bit to what my colleague, Dr. Haynes, said in relation to the ESL. The focus has been solely on players, on clubs, on the leagues. But there are two main players that were not really discussed. I mean, I've been following the chat on this on social media, etc. But two big things have not really been aired out. And one, firstly, is the broadcasters. The broadcasters stand arguably to lose the most because without the broadcasters, we don't have professional sport. The broadcast money is what really funds the clubs. So let's take Sky, for example, where 6 of these teams, or let's say at least 4 of these teams were English, right? Arsenal, Chelsea, Man City, Man United, Tottenham, so 5. These teams are the biggest teams, so to speak, in the Premier League. If they leave, then the value of the TV revenue and the value of the broadcast deals falls away massively. So there is a lot to lose for Sky, for example, who make billions of, or rather paid billions of dollars for the broadcast rights for the Premier League. And that is something that could have, even if, let's say, the clubs were on board with this decision to go to the ESL, that could have been a major sticking point if someone like Sky decided to intervene and say, well, hold up, I contracted with the Premier League for, rights, including 20 teams, of which these 5 are probably the key 5. And from that basis, my contract with the Premier League is affected, and I'm going to fight this tooth and nail. So that's one element I think that we need to focus a little bit more on in the general discussion. The second thing that, the second group of persons that were ignored, and I say ignored because I haven't actually seen anybody talk about it, are referees. And it's not just me seeking the, collectively my brothers and sisters in refereeing, but there was no discussion of referees. So FIFA didn't strongly denounce the Super League, but they didn't actually come out and say we're supporting this. And as we all know, all referees are FIFA sanctioned. We can technically only referee in FIFA sanctioned football. And this would have impacts for two things. One, referees would not be able to go to the Super League without losing perhaps their FIFA registration, their certificate, that kind of thing. Alternatively, what about things like insurance? Would insurance cover non-FIFA sanctioned football? And it's a big issue that nobody discussed. Of course, the Super League players would get insurance because, you have JP Morgan backing you. I'm sure some insurance agency would back you. But what about the referees? Nobody ever really takes into consideration the livelihood of a referee. So that takes us nicely into the second question, which Marshall posed, which is an excellent one, about the liability of referees, especially in the context of a video review era. I want to start by saying that the technology of video review being used in sports is not new. We have seen this in several sports. There is one little difference though. So whereas in the NFL, in tennis, and rugby, etc., there's been video review technology being used for a number of years, I want to argue that the stakes in football are slightly higher. The broadcast money is more significant. The money to be earned by clubs are more significant on average. So while the NBA, the NFL, etc., does have a lot of money in it, when you compare the broadcast revenue, the revenue earned by each team in the major leagues, they do typically stand to make a lot more money. So with the stakes being higher, there is a greater expectation that by introducing video technology that referees and officials get it right. But how do we interpret getting it right? It's not as clear as, or black and white as a right decision from a wrong decision. And that is part of the issue with using video technology, because it's still a large portion of human interpretation that has to be applied to, taking football as the example, the laws of the game, they have to be applied to very particular circumstances. There's been a lot of criticism about the use of the video technology itself. I mean, just anyone who does science knows about parallax error and these sorts of things. And when you look at some of the replay screens that the video assistant referee has to look at, you end up in a situation where you ask yourself, is this really the best camera angle that we can use? Is the camera in line with the play? Is it in line with the second to last play on the pitch? Is it in line with the ball? That sort of thing, right? Is it the case that the video review technology is actually working properly? So that in itself is a question. So maybe that raises questions as to maybe contractually, the person who provides a video review technology, they have to improve. If they are below their threshold as to the accuracy that they reported, maybe that's a breach of contract, and maybe the video review technology provider may be one at fault in this case. But this doesn't take away the discussion that referees may be liable as well. Traditionally speaking, officials are not normally held liable for any sort of harm suffered in a game, whether it's physical harm by a player who's injured or financial harm from the fallout of a decision. So there is one case that I'd like to bring everyone's attention to. It's a 1997 case from the UK. It's about rugby. It's called Smolden and Whitworth. And what happened here is that a rugby umpire was a rugby referee failed to enforce the rules of the scrum on a number of occasions. And in the final instance, what happened, the scrum collapsed and a player suffered serious injury, ending up with paralysis. So in that particular case, the rugby referee was held to be negligent and then held responsible for the injury suffered by that player. Where does VAR in football context come into this? Let's suppose, hypothetical here, that a particular referee, waves play on, is told by the VAR to go check the monitor for a potential foul or potential red card, that sort of potential red card for a foul, right? The referee says, nope, not a foul, or rather says, no serious infringement here, no red card. And the player continues on the pitch. That same player then goes on to, let's say, kill a player, seriously, grievously injure a player, that sort of thing. Is the referee now at fault for allowing that player to stay on the pitch if he should have been sent off for the earlier offense? Given the fact that VAR would have said, ref, come have a look at the monitor, potential serious foul play, potential violent conduct, whatever the case is. And the referee does nothing about that. So again, it's the element of having a second bite at the cherry for the referee that raises the stakes. Because again, if you know you get 2 bites of the cherry to get the decision right, does that create greater expectations? Does that evolve the standard of officiating? Does that raise the standard, or rather lower the standard allowed for what is allowed to be negligent in the context of a referee? So there is a current open question as to whether the video technology changes the expected standards of behavior of a referee. I am not aware of any cases where this has been brought up to say that it's looking that it's going to be more in favor of referees or less in favor of referees. But I want to draw everyone's attention to Law 5, Article 7 of the laws of the game, the most recent version, of course, 2020, 2021. And under Article 7, it takes us through the liability of match officials. So I'm just going to read the first bit for you. A referee or other match official is not held liable for 1, any kind of injury suffered by a player, official, or spectator. 2, any damage to property of any kind. 3, any other loss suffered by any individual, club, company, association, or other body, which is due or which may be due to any decision taken under the terms of the laws of the game or in respect of the normal procedures required to hold, play, and control a match. And the latter part is a really key bit here. As long as the referee is acting within the standards expected in the sport, he or she will not be liable for any injury suffered or any financial harm suffered by a club or anything like that. That is not to say that the liability of the referee will never happen. If there is negligence, it's possible seeing Smolden and Whitworth applied. Alternatively, if the referee seriously breaches the expectations that are placed on them via the laws of the game, via training of referees, etc., then you can have liability of referees. But what I would say is that with VAR, it's unclear as to, at this point, how it affects the expected standard of behavior. So this is something that does require a lot further study. But I know, and as a referee myself, I mean, I've made these mistakes in games. Would I get sued for that mistake? I'd hope not. But the reality is that I don't think I've ever witnessed in a game a situation where the referee has been so negligent that to endanger the lives or the health of a player. And far less when we're getting into financial harm, it's even less likely to happen just if you have an understanding of tort law. So in a very long-winded way to say, I don't think referees will be getting sued anytime soon unless they are being negligent on the pitch.
And just a reminder to those of you who are joining us from across the region and indeed across the globe, as we have over 100 participants registered from nearly 20 different countries joining us this evening. You can join the discussion in the comment section on YouTube and Facebook. You can pose your questions there. Our team is monitoring that space and will pass the questions on to us. Now, gentlemen, as we approach the summer of 2021, the 2020 Olympic Games is also another topic of discussion. And most notably, just a few days ago, the International Olympic Committee announced that it was upholding its much talked about Rule 50 as it related to athlete podium protests at the Games. Now, there was hope in some quarters that given the recent protests against racial injustice and so forth, that the IOC would have modified its stance. However, that was not to be. So now, Mr. Marcus, I'm going to put you on the spot. Could the IOC face, let's say, a legal challenge on the grounds of an infringement on an individual's freedom of expression or any similar consideration?
Thanks very much, Marsha. The IOC wields so much power that even when athletes may have legal avenues open to them, they're very hesitant to walk through those doors. But I think the IOC may be going into the Olympics this year thinking that they're in a position of strength, because that final decision to uphold Rule 50 as is, it came as a result of a survey that was done where just about 70% of the athletes surveyed were in agreement with not altering the wording of Rule 50. However, there are other athlete groups who have said, well, we're not surprised by those survey results. Those were your commissions, IOC. Why don't you go to independent athlete commissions to find out how they feel about it? So there is a bit of a tension going in to the Olympics where Rule 50 is concerned. And of course, it's at a time that's very sensitive globally. To think that, the death of George Floyd in May 2020 would actually be the catalyst for this type of global discussion, that even going into something like the Olympics, it's a major consideration. And, so the athletes who have said this is not right for the IOC to leave Rule 50 unaltered, they have definitely held the position that human rights issues are being raised, freedom of expression issues are being raised. And what's quite notable, Marsha, and to our listening audience, is that the United States Olympic and Paralympic Committee in December last year said, if our athletes use the Olympics as a forum to express themselves by taking a knee, raising a fist, they're not going to sanction them. So you actually have perhaps one of the most influential national Olympic committees holding one position and the IOC holding another position. So it really sets up a really fascinating narrative going into the Olympic Games. And I do think athletes now feel a lot more empowered, and I would not be surprised if some athletes say, you know what, there is no better space and no better forum than the Olympic Games to let my voice be heard. I'm going to do what I have to do and let the chips fall where they may. So, Marsha, I think it is going to be not just the sports that we're looking at. If Tokyo 2021 happens, and it seems as though it will still happen with very, very restricted conditions, but I think besides sporting performance, I think so many of us are going to be looking at the subplots happening, especially where athlete protests are concerned.
And just for a follow-up question there, for let's say Caribbean athletes or athletes from the Americas, you mentioned, going with whichever way the chips fall, but what kind of sanctions could athletes face from the IOC's end? Should they, win that gold medal, go on the podium, raise a fist, or whatever form of protest they decide to take? What sanctions or repercussions could an athlete face?
It could be twofold. The IOC itself has already set a precedent of expelling athletes from the games. So those who would have followed John Carlos and Tommy Smith in 1960 at the Olympics in Mexico after the 200 meters, where they would have raised their fists with a black glove on, they were expelled from the games. And that's something that remains open to the IOC. Sometimes the IOC will also leave it to the National Olympic Committee to make that decision. And so again, as I mentioned a little bit earlier, it sets up a fascinating situation, especially for the American athletes. I think the Caribbean athletes are probably not going to feel as empowered. And so I think they are probably more likely to play it safe and stay within the current confines of Rule 50. But expulsion tends to be the usual sanction applied in circumstances like that, maybe a loss of a medal. There's no prize money to be forfeited, coming out of the Olympic Games. So likely expulsion and maybe a loss of a medal if that was it.
Now, gentlemen, we had some questions submitted in advance from our participants who would have registered. And not surprisingly, a lot of these questions surround COVID-19 and the impact it has had on the sporting world so far. So Dr. Haynes, coming back to you for this one, in terms of COVID-19 and liability. Now, are there any liability concerns for a sporting association or an event organizer? Should it be confirmed that an athlete or even a spectator has contracted COVID-19 by virtue of attending a sporting event or through training and so forth? Should associations be worried here?
Well, I don't think that associations should be worried, because I do believe that most associations have implemented very stringent and certainly robust rules and regulations and certainly procedures to address the nuances associated with COVID-19 and the restrictions that must necessarily be in place. The prospect of liability is a real one, however. I think that invariably, insofar as claims for negligence are concerned, that possibility does exist, and it is a real possibility. But the question ultimately is, have the sporting organizations in question done what is reasonable in the circumstances so as to ensure that the individuals who might have contracted the virus did not contract those virus? That virus rather. So the challenge in this context is that it requires that the organization necessarily have appropriate rules and procedures in place, but not only have those rules in place to deal with COVID-19, but actually implement those rules. The reality is the burden really lies on national federations, because what we've seen in the past is that courts have said that the international federations, because of the spatial distance which exists between themselves and the players in particular, that liability may not necessarily arise in that context. But I think grassroots organizations as well as national federations stand to lose the most in terms of liability because of the proximate relationship which exists and which may very well give rise to a cautious claim. Invariably, it is foreseeable that in the event that you don't take appropriate measures so as to ensure that an individual does not contract the virus, that if the individual then goes on to contract the virus, that you could very well be liable. You know, we don't have a COVID-19 specific case on the issue, but what we do have are cases in the realm of boxing, for example, in which the courts have expressly said that in a discipline such as boxing, where the stakes are high and where the prospect of physical injury is real and profound, that appropriate procedures and regulations must be put in place, and that they must always be complied with by the sporting organization in question because of the implications if they're not complied with. So by parity of reasoning, then, it can be argued that given the significant deleterious impact potentially of COVID-19, that it is absolutely important that sporting organizations not only adopt rules and regulations to treat with the issue, but also to implement those rules, because a failure to do so may give rise to an argument that the organization has not adopted those measures which are reasonable in the circumstances so as to prevent harm being suffered by players or spectators, as the case may be.
And as a follow-up question coming in, how can we then guide sporting bodies to integrate COVID-19 measures into leagues as sport returns and gets back up and running? Any suggestions or recommendations out there for sporting organizations looking to finalize their return to play protocols?
Yeah, I mean, I think that's an excellent question. The United Kingdom government, they would have published very recently regulations and certainly prescriptions, which they have imposed on various sporting organizations and which must necessarily be complied with. And I think that's a good starting point. But also individual associations in the UK context and certainly in some European states as well have in fact adopted regulations to treat with COVID-19. And I think that those are good reference points. Now, there is an article at the moment being published, I think, or it has been published rather, in the Global Sports Law and Taxation Journal that treats with that particular issue. And, you know, it was something that I wrote about 2 months ago, which really addresses the potential pitfalls associated with COVID-19 and its relation to sporting organizations. And in it, I pointed not only to the potential for cautious liability, but also contractual liability, because there's a duty of fidelity, contractually speaking, on the part of sporting organizations. They must ensure that if it is that they've contracted with a particular player, that that player is not exposed unduly to circumstances which may cause that player to not be able to perform at the standard to which a player would ordinarily perform. And so I would say then, in direct answer to your question, that there are about 25 or so measures which have been prescribed by the UK government for sporting organizations to possibly adopt. And those may very well be good reference points.
And Dr. Go ahead.
Yes, if I could just jump in, just slightly related in the context of sporting organizations. This is not so much on the field of play, but one of the things that sporting bodies have started to do in 2020 as a COVID adjustment really has to do with more of their internal governance, especially something like elections. And what bodies have realized is that with COVID coming, their constitutions did not provide for virtual annual general meetings. So one of the things they have done for those who are maybe entering into an election period is to have an extraordinary or special general meeting for the sole purpose of amending their constitution, having that passed, and then they're able to actually convene virtually to be able to have their AGM. So it's another measure that different bodies have started to do, which is, of course, very, very practical. And I think it's one of the things that sporting bodies who may be going into elections may want to consider. And they probably will get, I think, cooperation and buy-in from their members.
And Dr. Koo, another COVID-19 related question for you. What recourse do spectators have, let's say for a sporting event that they've purchased the ticket, but it was later canceled due to any national lockdown or curfew periods? Are pandemics considered acts of God?
Well, thanks again, Marsha. And that's an excellent question. And it's not limited to the sporting context, because there was a huge issue in the UK in particular when they had their lockdown in relation to concert tickets. And there's been a broader discussion about rehashing force majeure clauses. So for those of us who aren't aware what a force majeure clause is, this is where you have unexpected instances, unexpected occurrences that happen that then make whatever it is you've contracted for impossible. And the wording of force majeure clauses have become much more under scrutiny than usual. Normally, what you'd have in a contract is you go on the internet, you find a force majeure clause, and you just slap that in, say any act of God, riot, strike, flood, these kinds of things. There were even some situations where force majeure clauses may speak to what is a pandemic as opposed to what is an epidemic. And we're not going to get into the science of the difference between the two. But if you fell within the wrong side of that camp, that may mean that your force majeure clause is inactive or inapplicable in the context I was talking about. So what you had happening is a lot of entertainment companies, contractors, that sort of thing, having to scramble to update their force majeure clauses. So how does this relate to a consumer? Well, it's a twofold decision. One is a financial aspect, and the other one is public relation, goodwill management situation. So on the one hand, you don't want to really piss your persons who would come to your events or persons who would have bought tickets off, because you may turn that customer away forever. So you want to be accommodating, you want to provide the entertainment that you were contracted to give. But the reality is, for example, let's use the example of Trinidad. We just gone back into lockdown again today. Who knows how this is going to pan out? Who knows when we are able to have a sporting event again? Just yesterday, I passed the Queen's Park Oval and I was saying, when am I ever going to go back into the Oval again to watch a cricket match? Who knows, right? It could be next year, it could be 2023, who knows? But let's say that the IPL hypothetically was playing in Trinidad this year. I bought my tickets in advance. What can I do? Well, the options are then very much going to be dependent on, well, what financial state is the event organizer in? Because they may not be in a financial state having put out a lot of money to organize the event to give you a refund. And then now we have to start talking about contract laws in the country. Is it the case that the organizer can merely say, we're going to honor your ticket for a later date when the event actually happens? Or what about if that event never happens and they have to give a ticket refund? So you have a lot of situations coming into play here, and it depends on what the country's refund and return laws are. On average, if the event is never going to happen, you have to get a refund, because what you paid for cannot materialize, and therefore the contract, in essence, and Jason mentioned the word frustration. There's a doctrine of frustration on the contract law. If the contract is frustrated, then you get put into the place that you were at the time you entered into the contract. So you get back your money in essence, yeah? But what happens if now the event organizer, because of COVID, goes insolvent and then can't pay you back? You're in a situation where you're in a long line of creditors that you may never see that dollar in your life again. So that's an unfortunate reality that a lot of people may face. And we're seeing this in particular with airlines that may have gone out of business, airlines who have very limited solvency and can't pay out anything. So it's relevant for travel, it's relevant for entertainment, it's relevant for sports. But the lesson I think that we have to learn going forward is that our, what we call boilerplate clauses in our contracts, we need to pay a lot more attention to them, because it's not just you stick a standard term clause in and hope for the best. You really need to be a bit more proactive, have a bit more foresight, and try as far as possible to take these events into consideration as it happens. I mean, it's a harsh lesson for a lot of people, but the law is what it is. If your force majeure clause was improperly formed, unfortunately, the consumer may be the one that ultimately has to bear the loss in this context.
And Mr. Marcus, sticking with contract-related COVID-19 issues, we have a question coming in from Tanya Goddard. With so many contracts in limbo with respect to the Olympics in light of COVID-19, what are some of the ways in which the parties can mitigate the effects? Also, in light of the restrictions, is it sufficient for parties to complete the contract, or must they do so in the required form as explicitly stated in that contract?
Yeah, I think, thanks for the question. Both Dr. Haynes and Dr. Kood have alluded to some of the applicable contract principles here. I think on a practical level, if there's a possibility of renegotiating the contract terms, that would be a great place to start, because when force majeure clauses are invoked, pretty much both parties are absolved from legal liability. Neither side is going to be held in breach simply because it was one of these unforeseen acts of God, natural disasters, etc. And so what you would find is that both parties, from a practical point of view, would try to say, hey, is it possible for us to renegotiate the terms so that the contract can still be fulfilled? Now, it's one of the differences in terms of the legal effect of frustration as compared to invoking a force majeure clause. With frustration, it typically results in termination, probably sooner rather than later. With force majeure, there's a possibility of suspending the contract. So it may not just come to an end immediately, but there's an opportunity. Hey, let's see what can happen. Classic example would be the Olympics. Yeah, and I think for a lot of the reasons that Dr. Koo would have mentioned, it's part of the reason why the IOC and the Japan Olympic Committee and the city of Tokyo, the three parties to the host city contract, they would have been doing everything possible to have the games happen. They really do not want to cancel the games. And that's why this concerted effort is this. It's not because, well, people might be thinking, well, you guys love sports so much, or you don't care about people. No, it's just that it's very complex legal issues. So Ms. Goddard's question is a good one. I think practically the parties will try to negotiate to see as best as possible, how can this contract be fulfilled, even if it's 3 months later, 6 months later, a year later. Other than that, though, the doctrine of frustration may kick in and the parties may have no other choice but to walk away from it.
And just this week, the IOC updated its regulations for the Olympics for athletes and officials, outlining what must be done, the number of tests to be had before you enter Japan, requirements for physical distancing, and so forth. But we have another COVID-19 related question as it relates to vaccines for athletes. Is it legal for players to be mandated to be vaccinated in order to participate in sporting competitions? This question comes from Peter McDavid. He wants to know if it is indeed legal, under what statute?
I think I might take a bite at that question. So in principle, as part of your contractual obligations, you are required to do that which is necessary for the purposes of effecting those obligations. So if you're required to play, then you must do that which is necessary to play. And that may very well involve taking appropriate medical procedures, including appropriate vaccinations. The challenge, however, arises in the context of human rights, which now have become the worldwide mantra. Everybody's claiming that they have a right of conscience, the right to refuse vaccinations, as the case may be, on religious grounds, but also on other grounds. The position of the law in relation to this particular issue as such is that the particular measure in question must serve a legitimate objective. So in this instance, the objective that is being sought in the imposition of mandatory vaccine requirement is the protection of public health, and that is indisputable. But then it raises another question as to whether or not the restriction that has been imposed, i.e. the mandatory vaccination requirement, is proportionate, is rational, is reasonable in the circumstances. And as a corollary to that, whether or not there are lesser restrictive measures which can be enforced in order to achieve that particular objective. It may very well be that in light of the serious nature of COVID-19 and the fact that its ease of contraction is something that has been well reported in academic literature, that the position may very well be that unless an individual is indeed vaccinated, that individual should not be allowed to participate in events in relation to which he or she may contract the virus, or in fact, other persons may contract the virus from that individual. So I would say then that as a question of reasonableness, as a question of proportionality, which forms part of human rights law, that it is indeed a rational decision to require an individual who is desirous of participating in a team sport in particular to be appropriately vaccinated. However, just very briefly, there's another issue which arises in this context, which is that of restraint of trade. I mentioned it slightly earlier, and just to reiterate, again, the objective that is being pursued here is a valid one, which is that of the protection of health of athletes and spectators and training staff, as the case may be. But then the ultimate question then that is asked is the imposition of a mandatory vaccine requirement reasonable? And if the answer to that is yes, and I may very well hasten to say that it is, then the burden then shifts back to the player to say, essentially, that even though it is reasonable for this particular measure to be imposed, it is not in the public interest for this measure to be imposed. Now, we can debate and dispute as to whether or not it is in the public interest to impose vaccine as mandatory requirements. But I'd very much say that the preponderance of thought, academically and otherwise, seem to suggest that in close confines and in team sports in particular, it may very well be a rational and reasonable decision to require the imposition of vaccines mandatorily as a condition to participate in sport.
And Dr. Koo, do you think there would be any distinction here, let's say, with sport at the professional level where athletes are contracted, as opposed to amateur sport, where, for example, here in the Caribbean, a lot of our sporting federations, our national Premier Leagues, etc., operate at a very amateur level? Would it be a fair or reasonable expectation for amateur level athletes to be required to take vaccinations in order to return to play?
Thanks again, Marsha. And Marsha, I think that's the most difficult question we had for the night. So is there a difference between amateur sports and professional sports in that context? And we have seen in the past where the standards expected for what, in terms of a professional athlete versus an amateur athlete are indeed different from the point of view of a court of law. In terms of vaccination, it's really going to come down to, well, one, is it legal? And Dr. Haynes would have mentioned at some length in the detail, the sort of fundamental rights or human rights elements involved in allowing for that decision to be made on behalf of athletes, because it's not the athlete making the decision. It's the governing body for the sport that's going to make the decision. And this is now where we have this sort of hierarchy or tiers of sporting governance coming into play, because at the highest level, let's say it's the IOC hypothetically may say, yes, you need your vaccine to come to the Olympics, or you don't need your vaccine to come to the Olympics. How is that filtered down into the national governing body at the local level? That is ultimately the question. So if it is the case that a national governing body is going to impose a regulation to say that athletes have to be vaccinated, they have to double check that that is going to be in line with the sort of policy decision that has been made at the international level by the international governing body for the sport. There are also then going to be more general considerations. So what happens in a situation, and this goes a little bit further than what Dr. Haynes would have discussed, what goes on in a situation where an athlete cannot take the vaccine because there are some individuals who, for whatever reason, allergies, etc., may not be able to take the vaccine? Is this going to be the case that now they can no longer participate in sport, even though it's amateur? And that makes, you see, the restraint of trade issue at that point may become a little bit more problematic to apply, because they're not earning a living from playing this particular sport. So the stakes are different, the rules are slightly different. It's going to really come down to what the policy decision of the country is. It's going to come down to the policy decision of the national governing body that monitors that amateur sport. So I don't want to say yes or no either way. I've just more or less given the conditions for consideration that a governing body would have to make, that a league will have to make. So If we put this in the context of Trinidad and Tobago, let's say it's football, the North Zone Football League may say, look, if you want to play in the North Zone, your players have to be vaccinated, your staff have to be vaccinated. That might very well mean that if, let's say, a number of clubs take a stance and say we're not going to vaccinate, then what does the league do? They're placed in a very rock and a hard place position of, well, these players can't play, or these teams will not compete, and then you might end up in a situation where the majority of your league is not competing. Is it then worth playing sports in that sense? So we have to weigh that challenge up as well. But that's a very difficult question.
Now, gentlemen, we talked about the Super League earlier and the questions it raised in terms of governance and integrity. There is a school of thought that this is a sign of things to come in terms of challenges to the governance structures of major governing bodies. And we've had a couple of governance-related questions being submitted. So, Mr. Marcus, I'm going to come to you first. Jared Hart, he wants to know, what would be some of the key areas when constructing frameworks for constitutional reform, bylaws, and a governance policy?
Yeah, thanks for the question, Marsha. Good governance in sport continues to be very prominent conversation, especially within the past decade or so. And good governance, it's very broad in its scope. I think the starting point for sporting bodies would be just an issue of compliance, and depending on the framework within which your governing body is established, it may be compliance with the Olympic Charter, which is really the statutes of the International Olympic Committee. It's really their constitution. Because of this sporting pyramid, which really is a product of the European model of sport, you find that you have a contractual relationship from one level to another. International federation at the top of the pyramid, continental federations, national federations, clubs, etc. So you really find that from a governance perspective, a sporting body desires to be in compliance with the rules and regulations of its parent body or international federation. Of course, in Trinidad and Tobago, and I wouldn't go too much into it, but we had the fascinating case last year with FIFA and the TTFA, and that just raised a number of governance issues. And to add to that, you brought into the question just national law and the fact that the Trinidad and Tobago Football Association was incorporated by an act of parliament. And so what you had ventilated both at the High Court and the Court of Appeal level is, who does the TTFA show its first loyalty to? Is it to the Act of Parliament, or is it to FIFA, its parent body? So compliance isn't always that easy. So that would be the starting point for a sporting body. What is compliance going to look like? Yeah, because as has been part of the context of the conversation, a poor governance could lead to lawsuits. Athletes have educated themselves, administrators have educated themselves. Sport has become a lot more contentious, a lot more litigious. So it's important that those who sit in the seats of sport administration understand that it is no longer the car trunk situation that applied 20 years ago, but legal eyes are looking on the way that sport is administered. Let me just also mention as well too, your governance structures and issues of compliance could also impact on your state funding, which is very contextual for the Caribbean jurisdiction, where most of our countries are dependent on our government for funding. And of course, it also raises the other issue of, responsible autonomy that the IOC speaks about. But that's another motivation for good governance. You want to be able to continue to receive support from the government, especially in a Caribbean context. So I think with all those things in mind, it's important that those who sit in the positions of authority don't get comfortable. They're always reviewing their constitutions. If you've become incorporated under your Companies Act, you're looking at your bylaws, and just really modernizing the way that your structures are set up, and really keeping in consistent with international best practice in sports governance.
And Mr. Marcus has a follow-up question coming in from Adam De Silva. He's asking for an association to be recognized by the Ministry of Sport and the international body it is aligned to. Would it be legally required to register with the Ministry of Legal Affairs in Trinidad and Tobago?
Not necessarily. It's a good question. It's not, well, I'll put it this way. Many countries, including Trinidad and Tobago, Jamaica, Guyana, many countries around the Caribbean, Anguilla, many places have national sports policies. Sports policies would what we would consider to be soft law, and there may be recommendations in the sports policy for national governing bodies to incorporate. It may not necessarily be a statutory requirement. However, because of the legal protection that comes to your individual directors, it is often advisable that sporting bodies do incorporate under their relevant company's legislation, so that it is the company itself, it's the separate legal personality that arises, and that's the company itself that would absorb the risk as against the individuals, and of course, other benefits like, suing in the name of the company, being sued in the name of the company, entering into contracts, owning property. So it is more advisable as against a strict legal requirement, but it may vary depending on the country that you're in.
And Dr. Haynes, a question about from the Olympic level, from Ranjit Prasad. What suggestions or recommendations would you have for Olympic committees in terms of meeting the minimum legal requirements as an Olympic committee based on our regional culture?
I think I believe that Tyrone might be a more appropriate place to answer that question, given that he's worked in the capacity as a senior legal officer in the Ministry of Sports, I believe, in Trinidad and Tobago. Tyrone, might you?
No problem at all. And I think it's somewhat related to the previous question. Again, with national Olympic committees, they are definitely one of the core constituents of the Olympic movement. The Olympic Charter actually says so. It speaks about the national Olympic committees, it speaks about the International Federation and the IOC as your core constituent elements of the Olympic movement. So as a starting point, national Olympic committees want to be compliant with the Olympic Charter. They should be familiar with it. And the Olympic Charter tends to be updated pretty much every IOC session. Annually, they'll make different amendments. So we could expect some amendments to the Olympic Charter in July, just before the Olympic Games would begin. So where Olympic, and if I could mention, you actually have a branch of the law evolving called Olympic law. Yeah, you've had more and more Olympic committees, whether the Court of Arbitration for Sport, usually sometimes in the national courts. And so even with the development and the evolution of Olympic law, that too now becomes a framework within which national Olympic committees in the Caribbean would want to fall within. I'd also add as well, the Caribbean Association of National Olympic Committees, CANOC. CANOC is well placed as a Caribbean umbrella body to provide that kind of guidance for the regional Olympic committees. And so I think it's a little bit easier for the NOCs. They want to look at the Olympic Charter, be familiar with its mandates, and the IOC is often an open door to be able to provide guidance in terms of what the Constitution should look like, what their contracts and everything should look like. So I think the Olympic Charter really speaks loudly in that context.
And Dr. Koo, Mr. Marcus just mentioned Olympic law, but we have a question from Anthony Gafour, who's asking, to what extent is it now possible to speak about a Lex Sportiva or a discrete body of sports law?
Okay, thanks. And I actually, when I give my statement on this, I want Mr. Marcus and Dr. Haynes to jump in as well, because I think I may be the one odd duckling here that is a Lex Sportiva skeptic. And Mr. Marcus and myself have had lovely debates about this in front of our class when we co-taught Commonwealth Caribbean sports law at St. Augustine campus. And there was some excellent discussions that we had. It's actually, Mr. Marcus had really brought me into the fold of sports law, because by trade, I am an IP academic. So it's really Mr. Marcus I owe for getting more deeply involved with sports law. So my answer is this: what is Lex Sportiva? Well, the idea is that persons who believe in Lex Sportiva, advocates for Lex Sportiva, gives the impression or the idea that sports law is now something in and of itself. It's not just the mere amalgamation of traditionally accepted laws. it's not just a situation where you you apply sporting context or sporting situations to your traditional legal context. It's taken on a bigger and a deeper breadth than that. And Mr. Marcus would have mentioned Olympic law, and Olympic law is one of those clear-cut areas that Lex Sportiva advocates would say, look, this is why we have Lex Sportiva. This is why sports law is its own area of law. And there's some other areas that we can mention that fall within that category. So areas like the laws on doping. Doping has the laws on doping have some very particular requirements. So, for example, that whereabouts provision that athletes need to be, need to notify the Olympic Committee or their national governing body, etc., or for WADA, etc., for where they are for experience. So they're under constant scrutiny, under constant monitoring. For example, when they have to go submit their urine test, somebody follows them into the bathroom, they have to check and make sure that it's actually them, giving their bodily fluids rather than, so we had Mike Tyson with fake appendages. We had other athletes, hiding packs and sacks all over the place, to give someone else's urine if they're going to fail because of, taking performance enhancing drugs or narcotics, etc. So there are areas of the law like that which speak very clearly to, well, sports law is evolving. This is not like any other existing area of law that we've seen. But in other contexts, we see contract law, we see tort law being applied in sporting conditions using the same principles that have always been thought about in a traditional legal way. Intellectual property law is being applied in a traditional legal way. So the way that I see it is that sports law is a spectrum. So on the one end, you have, let's say on the far left, you have no sports law, no Lex Sportiva. It's just traditional legal principles being applied in sporting context. On the far right end of the spectrum, you have Lex Sportiva saying that, look, these are areas of law that, even though they're sporting context, the legal principles themselves have evolved and are given a very different meaning in the sporting context. But in reality, I see it as a hybrid. There is no clear-cut area. For example, in my own field, intellectual property, football broadcasts have actually influenced the development of what we call a live injunction. So without the value of football broadcasts, there would not really be a live injunction, which allows courts to give to the person bringing the case the ability to block a stream that pops up while a football match is on the air. And it started with football. It's gone over into boxing, UFC fighting, etc. MMA. So I am a sports law skeptic, and I am not ashamed in saying that. And I know lots of colleagues may say, well, how you could say that when you're teaching sports law? But I think as an academic, that's the beauty of it. I can teach something and not necessarily say that I am a supporter of it, but give you all the perspectives on it and let my students, let colleagues make up their own mind in relation to, does Lex Sportiva exist? But in my opinion, it's a hybrid. We can't say that it's completely divorced. Sports have, sort of influenced the development of laws, but to say that Lex Sportiva is its thing in and of itself, I am still skeptical because of the fact that traditional legal principles have taken it to this point, and I don't think it has sufficiently departed to say that it is completely its own thing. But I do accept that certain areas, like doping, like Olympic law, we will see some principles that may vary. So maybe I want to turn this over to somebody who is perhaps a Lex Sportiva advocate to give the other side of the story.
Well, I may want to point to the Court of Arbitration for Sport as the epitome of the notion of Lex Sportiva. In fact, the Court of Arbitration for Sport in and of itself has developed this notion of the specificity of sport, which underlies every decision which it makes. And so when you look at the jurisprudence emanated from the Court of Arbitration for Sport, which touches and concerns all areas that would affect athletes, discipline, selection disputes, among other things, you could very well see that although there are shared sort of similarities with traditional areas of law, there are also significant differences. You mentioned doping as an example of one of those areas in which we've seen significant differences in terms of how the law treats with this issue of sport as a special area of law. But also we see in respect of, for example, a breach of contract by a player, or in the alternative by a club. The court taking this notion of the specificity of sport into account in terms of the award of damages, such that damages don't necessarily only reflect the fact that an individual has suffered loss, but the fact that an individual who might very well have been a player then has to go on the market and have to compete with a number of other individuals, and then that individual still may not be selected. And so it places that individual in a very disadvantageous position. And so the court looks more prospectively at the potential loss of that individual rather than retrospectively as to the individual itemization of the special damages as such, if you want to describe it as such. So I'd very much say that when I look at the Court of Arbitration for Sport and the Lex Specialis, which arises in that particular context, I can very well see emanations of sport law. But I do agree, Dr. Koo, rather, that we must see it as a spectrum. I think sports law is somewhere in the middle. And in fact, in my conversations with my students, I often wonder, and I threw out the question on numerous occasions as to whether or not this notion of sports law is really a gimmick. It's a marketing gimmick so that people would identify with this particular discipline. Students will be interested, lawyers would have a discipline which they can say is their own, and it would be all good in the interest of capitalism. But at the same time, I'm conscious that other areas of law have gotten their own identity. Employment law is essentially contract law, yet it is recognized as a species of law. Medical law is a recognized discipline. Nonetheless, it really and truly, in its essence, is tort law. So why is it that sports law, in the iteration that we know it, should not be conceived as such? When, as Dr. Quiz mentioned, there's so many elements which point to the development of this discipline called sports law.
Actually, the only other thing I would add, and it really is a fascinating discussion. I think the term that Dr. Koo used is, I think it's probably one of the best ones we could think about in terms of the spectrum, but the conversation is so nuanced that in academic circles, you have different terminology that is used. So you have domestic sports law, which is defined differently from national sports law, which is defined differently from global sports law, which is defined differently from transnational sports law, which is defined differently from international sports law. And the fact that you have all of these different layers, I think speaks to the fact that it is a spectrum. I think even those of us who practice or teach in the area acknowledging where exactly do we land. And if I can just close this particular question by going back to Dr. Haynes mentioning the Court of Arbitration for Sport, the standard of proof before the Court of Arbitration for Sport is neither a criminal law standard, all right, beyond reasonable doubt, or a civil law standard, balance of probabilities. It's this new standard called to the comfortable satisfaction of the hearing panel. Comfortable satisfaction, that could be nothing else but sports law. Yeah, but it's now moving a little bit in that direction, but it's one of a few things like that. I mean, in football contracts, we have termination for just cause, but then there's also sporting just cause. Yeah, and that now is a part of football law. There's an entire book, Marsha, called A Football Law, written by a Queen's Counsel in England. And so the conversation could continue, but I believe we may have other questions. So let me rest it right there.
Yes, definitely. We have some questions coming in terms of liability as well as intellectual property. But before I move on to those two final areas, Dr. Haynes, an interesting question as we were speaking about CASI, Court of Arbitration for Sport, from Devika Samuel. What role could alternative dispute resolution play in resolving sport-related disputes? And could there be a formal arrangement to use ADR? Sometimes here in the Caribbean, we see some of our sporting disputes ending up in the high court and so forth. So is there room for ADR in sport in the Caribbean?
Oh, absolutely. So just to provide some context, many sporting disputes, not only in the Caribbean, but also in other jurisdictions, are resolved through alternative methods of dispute settlement, namely arbitration, mediation, negotiation, even in some instances, conciliation. We've seen a number of cases in the Caribbean context, including, of course, the Thema Williams decision, in which those cases should probably have been directed to arbitration, or indeed mediation to be resolved as opposed to going to the courtroom setting. Principally because at the end of the day, sport is a type of a familial relationship in which much depends upon the maintenance of good relations. One of the things that is self-evident with court proceedings is that it fractures relationships. And so mediation as an alternative to court proceedings allows parties to adequately resolve their disputes, have their voices heard without necessarily ending up in an adversarial state in which their future relations are actually prejudiced. Now, it is important for athletes in particular to have these disputes resolved in an amicable way. One, because speed and having things resolved with alacrity is an important consideration for most athletes. They don't have a significant amount of time within which to go before the court and fight up to get an ultimate outcome, which may take 2 or 3 years. So if we're talking about efficiency with respect to speed, if we're talking about confidentiality, which is needed in many instances, because many contractual disputes, for example, relate to salary, and many athletes may not want that information in the public domain, then I would very much suggest that alternative dispute resolution should be the forefront of our conversation. Now, I will let Mr. Marcus in on the conversation in a bit from now, insofar as how the Caribbean has responded and his own work insofar as proposals for the development of arbitration and mediation in the region. But just to say that I think now courts themselves, lawyers, and of course, athletes are moving in the direction, rightfully so, of utilizing more and more these alternative dispute resolution methods because they offer better solutions compared to the controversial and adversarial courtroom process.
Yeah, the thing I would build on from what Dr. Haynes is saying in particular is especially within the sporting context, the preservation of relationships is really important. And, you know, from a Trinidad and Tobago context, we saw the fallout with the Tima Williams case going into the Rio 2016 Olympics and the sudden replacement of Tima Williams with Marissa Dick and how that fractured the relationship between Williams and the Gymnastics Federation. Trinidad and Tobago's football team, the second in the English-speaking Caribbean after Jamaica, to qualify for the Senior World Cup in 2006. And yet, 2 years after that, there was a bonus dispute ending up in court. And by the time the South Africa 2010 World Cup came around, quite a number of those players were blacklisted. And it seems to be directly connected to the court action, another fractured relationship. And so, you know, conversations have been going on for a number of years now, and we're happy that people like the Caribbean branch of the Chartered Institute of Arbitrators, CANOC, as we mentioned a little bit earlier, even the Caribbean Court of Justice, all right, different national Olympic committees around the region, they are buying into the idea of sports mediation and sports arbitration really blossoming in a Caribbean context and being populated by Caribbean jurists. So I will just kind of plant that seed at this point. Hopefully, after the completion of the Olympics, that conversation will be able to get some traction again. But Marcia, it is our belief that the Caribbean has the expertise, the experience, the passion, the knowledge, the people who can populate panels, all right, within the region without having to go to Switzerland all the time. And of course, virtually things are a little bit different now. But the Caribbean has the people that we can really have our own sports mediation and sports arbitration panels. And it can really serve the athletes in the best way possible, which is getting them back on the field of play as quickly as possible.
Now, gentlemen, we had a series of questions as it related to liability in sport, all surrounding sport injury. So, for example, someone asks, this is Miguel saying, how can sports law be incorporated into biomechanics to rate unpredictable injuries? David Messiah was asking the conditions under which athletes may take legal action for injury. And Veronica Harris, what are the laws governing injury sustained during sporting activity? Dr. Koo, if you could just give us some insights here as it relates to sports injury, what recourse do athletes have?
Sure, and this is an interesting question because obviously as player, myself, Mr. Marcus is also a player, we've played a football match against each other. We don't want anyone to get injured, but inevitably injuries happen. So there are a bunch of different parties that are at play here. So we've spoken about the liability of referees for for injuries that may happen or liability in general. The referee has a role, or the umpire or whoever's in charge, the official has a role to ensure that the pitch is inspected properly and things like that. So that is something that has to be taken into account. But ultimately, the main parties that may be liable here would be the persons who operate the ground. So you want to ensure that the premises is safe. And this is in relation to both fans, the officials, and the players. There have been cases where, for example, the football goalpost wasn't pegged down properly. It fell on someone, they got injured, and the person who operates the ground is liable for it because they didn't do the due diligence and do the checks to make sure that the goalposts were pegged down. What actually happened in that case, somebody removed the pegs to use for a tent or something like that, if I remember correctly, and the goalpost fell on someone and damaged them. Alternatively, if you are the groundsman or you are the operator of a sporting ground and there's let's say a crevice, crack or something like that in the pitch, someone steps in that, twists their ankle or breaks their ankle, etc., you can be liable for that, just like how you're liable under occupier's liability in the traditional land law sense. So you have to ensure that the premises are kept up to standard. The more, I guess now the more topical issue and the more relevant issue for discussion, because everyone is more concerned about this part, not so much the liability of the club or the liability of the ground owner, etc., for the premises, but what happens if another player damages you? I had the unfortunate situation where I was an assistant referee in a match at the stadium, the Crawford Stadium, on the training pitch, and a player suffered a broken leg. It was not a terrible tackle. The pitch was wet. The player did come in quite hard. Yes, he was sent off, the player that is, but did he mean to break that person's leg? No, he did not. And this is an unfortunate reality of playing contact sports, and severe injuries do happen. But what is a liability of a player in that situation? The player who committed the foul. So the case law would tell us that there are about 6 or 7 criteria that are laid out that the court has to sort of take account of in determining if that person is going to be liable. And there can be both criminal liability and there can be civil liability. So if it's criminal liability, we're talking things like GBH, grievous bodily harm. But to prove that, you have to have some level of intent to cause that injury. So for example, this is the one that we've typically given in a problem question for students. You hear somebody whisper in the locker room, or you hear somebody whisper in the tunnel, yeah, have it in for you, or going to arrest one on you or something like that. That same player comes in, hits your devastating tackle, and you've suffered some serious harm. We've had situations where goalkeepers have run into players with their knee intentionally or arguably intentionally, and that has led to liability. But then you have situations where players are negligent. So for example, there's a hockey case where the player swings the hockey stick and makes contact with what is termed in the case the right orbit of the player, and the orbit is, it explodes. So I don't want to give any more graphic description of that, but a right orbit exploding. So your eye exploding. Think what you want of that. But those are the kind of injuries that you have happening, which are very serious, very severe. And the question is, how does the courts deal with this? So you have to look at, was it intended? Was this something that's expected in the sport? So for example, just because someone slide tackles you and breaks your leg in football, that is not necessarily going to lead to civil offense or criminal offense, because that is something that is expected in football. Person slide tackle, that is permitted under the rules. If it leads to injury, well, you have to see, how bad was the tackle? Was this a jump kick in mid-air, or was it a sliding tackle on the ground? So if someone slides on the ground trying to play the ball, it might be a bit high, you're probably not going to get that person being held liable under civil law. However, if somebody jump kicks you in the back when you're not expecting it off the ball play, you're probably more looking at legal liability for something like that. So let's recount situations like Eric Cantona jump kicking players, jump kicking fans, all sorts of things like that. You're probably going to look into liability for something like that because it's not expected in the sport. And I'm sure Mr. Marcus or Dr. Haynes have some other examples to share. But the idea is that if it's expected or comes within the realm of what is expected in the sport, it's not going to lead to liability.
Well, gentlemen, as we move toward the close, we had a couple of questions as it related to the future of sports law in the Caribbean. For those interested in becoming involved as practitioners or making a contribution to, for example, the alternative dispute resolution aspect of things. So Dr. Haynes, what advice would you have for someone interested in becoming involved in sports law in the Caribbean?
That's an excellent question, because the truth is, as much as we've produced in the last couple of years more and more students, the playing field with respect to practitioners of sports law in the region is still, compared to other jurisdictions, quite small. And so I'd very much suggest that people who are interested in sports law, that they engage in professional development courses, whether it's of an academic nature or strictly professional nature. Oftentimes, sporting organizations run these courses. CANUP in particular, I know that Mr. Marcus and I would have run training for CANUP just a couple of years ago in St. Vincent, bringing together sports professionals from throughout the region. That is certainly a good avenue as well. But various other cognate organizations also put on activities and training that relate to sports law. Not necessarily directly, but they may very well have some relation to sports law. I think, for example, of the Chartered Institute for Arbitrators. They run arbitration courses as well as mediation courses, and they therefore would allow you to get a very robust international qualification in arbitration and or mediation that allows you later on to practice in the field as an arbitrator or mediator. It may very well be that other institutions, such as the Center for Effective Dispute Resolution, runs mediation training. That might be something that is of interest. And invariably, these things oftentimes come at a cost, but the challenge, or rather the prospect, is that they pay off. They may not necessarily pay off immediately, but I think investing in yourself is really important. You know, when I first met Mr. Marcus, one of the things that he mentioned is that, you know, at the very outset in the Caribbean context, when sports law was not a real big issue as such, and there were very few people practicing in the discipline, he felt that he should invest in his academic studies, further his studies, complete a master's in the area. And as a result, now he's one of the leading sports law professionals in the region. And so that, of course, is not an isolated case. I mean, there are many other cases I can speak of in which persons have gone on, pursued academic and professional qualifications, and are now well recognized in the discipline. And so I'd very much encourage people to invest in yourself, and those investments will invariably be rewarded, if not immediately, certainly in future.
Marsha, I'd love to add to that. Thanks very much, Dr. Haynes. And, you know, simply say, as Dr. Haynes mentioned, investing in education, sometimes it may mean educating yourself first and foremost. I had a lot of support in the early days, just in terms of people who would, you know, just buy me sports law books that I could read, you know, before I had the opportunity to educate myself. So I think education is one, and there are many opportunities for sports law education right here within UE, right, and other places. And then the other thing I would mention is be willing to volunteer at the outset. Even before my own sports law career would have started, I had to be quite satisfied with volunteering, just simply to be able to build relationships and to be able to get practical experience in reviewing a sports constitution, reviewing a sports-related contract, etc. So I think those who might be interested, make yourself available. The Caribbean community is a connected one. Make yourself available, and I think as you refine your skills, eventually remuneration opportunities will come.
And Dr. Koo, I'm going to give you the final word, because as we sit here this afternoon discussing governance, regulations, COVID-19 and so forth, there's so many other sporting issues we could talk about: intellectual property, sports marketing, etc. So this forum is actually just the beginning of things to come as it relates to sports law in the context of the University of the West Indies. So could you give us, you know, a taste of some of the other projects that might be on the horizon?
Yes, thanks, Marsha. And yeah, this is really just the beginning of a much larger project, which we, theorized together. And it really comes off of the back of the success of the 2018 sports law workshop that we held at St. Augustine, which Mr. Marcus and myself organized. We had Professor Ian Blackshaw coming from the UK. He was our keynote speaker. We had a bunch of other local persons speak, which was really fantastic, really excellent. We were planning to try and get something done maybe in 2020, but then, you know, with the whole COVID situation, things did get slow, did slow down, teaching obligations, etc. So then we decided, look, we need to get something done. There's so much interest in sports law. There's so many sporting issues happening. It's going to be really exciting. So we came together and we said, look, let's start with the webinar, which was today. You know, we had a good discussion about it. I think everyone in the audience would have enjoyed it. But this is just the start. So our next big thing that we have planned is a sports law conference. So while this was a roundtable discussion, we're going to have something a little bit more formal with a lot more, not necessarily law related, but a lot more critical, targeted discussions about sports law issues and sporting issues. So in that conference, what we can expect is maybe 3 or 4 big themes on different areas of sports law, and we'd have persons from different academic backgrounds, professional legal backgrounds, maybe even some athletic backgrounds coming in and chatting presentation style about some of the hot sporting issues that are currently ongoing or will happen in the future. So some of those topics that we may not have checked on today, like intellectual property and sports, that's probably something that's going to be discussed. We probably will discuss a lot more about the governance issues in one panel, for example, but nothing is in stone at this point, and we're really grateful for all of those who tuned in today and did send their questions, because it gives us an idea as to what the interest is in the region and how we can go about planning our future conference. Off the back of the conference, we are also in plans, or rather discussing plans about the creation of a micro-credential course in relation to sports law. So you can come in, learn about sports law in a very education-oriented approach. So it's like you attend a class, you learn about sports law, and then you can take that, internalize it, and use it in your daily practice. If you're a practicing lawyer, if you're an administrator in a sports organization, you can use that to help bolster your administration. You can help bolster your constitution, those sorts of things. And again, we're still very much in the planning stage of it, so do look out for it. The Faculty of Sport, as well as the faculties of law, will be heavily involved in this process. We will look to see what international speakers we bring in, and international educators as well. So it's not just going to be us, even though we have a very, very highly decorated cast of speakers as illustrated here today. I've met some other persons through sports law at our workshop in 2018, and we have an excellent cast of professionals and academics. So it's something to look out to. Do reach out to us and air, the sort of topics that you might want to learn about or you're interested in hearing more about, because this is going to be the first of many sports law talks. And I speak openly here for Dr. Haynes and Mr. Marcus. I really enjoyed this talk. The questions were excellent, and I look forward to doing it again and engaging with more people about sports law.
This has indeed been an engaging and enjoyable discussion. So thank you so very much, gentlemen, Dr. Haynes, Dr. Koo, and Mr. Marcus, for your expert analysis and guiding us through these various legal issues, as well as a special thank you to our technical and administrative teams who would have been instrumental in putting this forum together. So on behalf of the University of the West Indies Faculty of Sport, as well as the faculties of law, I am Marsha Boyce, and I want to thank you, the participants and viewers, for joining us this evening. Do continue to be safe and enjoy the remainder of your day. Good evening.